Hello, students. I welcome you all in the lecture number 4 of Indian Contract Act, which is a part of CA Foundation as well as Clat lecture series sponsored by Shrijendra Rangzone. I'm your mentor, Shekhar Gehlot. So, we were discussing essentials of valid offer. Okay, so we are discussing essentials of a valid offer. I'll just go for a quick recapture of what we have done in the previous classes. Essential of a valid offer is it must be capable of creating legal relations. Okay, offer should not be such which does not create legal relations. We have discussed there may be social invitation or religious aspects to it. It must be certain, definite, and not vague. It must have a clear understanding. Okay, A offers to sell B 100 quintals of oil. Now this is a vague offer because oil can be of various categories. It must be communicated to the offer. It has to be communicated to the offeree, and in this we had discussed a case of Lalman Shukla versus Goridat, wherein Goridat issued an award, declared an award, but Lalman could not listen to this particular general offer, and he searched the boy and delivered it to Goridat, but still he could not claim the award because he was not the acceptor of the offer. It must be made with a view to obtaining the assent of the other party. It cannot be a general statement, it has to be actually an offer. It may be conditional. Okay, offerer may ask for payment by RTGS NEFT. Then in that case, payment has to be done through that particular mode only, and there can be so many other conditions as well. Offer should not contain a term, the non-compliance of which would amount to acceptance. It should not have a term such as that if you do not reply within a week or within 30 days, I'll assume that you have accepted the offer. This is not the way we are going to enter into a contract. The offer may be either specific or general. We have already discussed in the previous chapters. Now, for today, offer is different from a mere statement of intention and invitation to offer. A mere communication of information, casual equity should be casual inquiry, a prospectus, and advertisement. Now, you all must understand that an offer, when made for a contract, it is different. Okay, then now all these categories are exceptions to an offer. What are the categories which are exception to an offer? Mere statement of intention is not an offer. An invitation to treat. Okay, these things do not constitute a valid offer. Okay, these are mere publications or mere informations provided to the public about a product, but this does not mean that someone who is issuing these statements is also willing to is making an offer. He is not making an offer at all. Okay, let us understand this in detail along with the help of a case law. An invitation to make an offer or do business. Okay, in case of an invitation to make an offer, the person making the invitation does not make an offer, rather invites the other party to make an offer. Now this is a very key statement. The person making the invitation does not make an offer. Okay, the person who is making an invitation is someone like, suppose I am a suppose A has a clothing shop. Okay, and displays a host of various clothes with MRP tags upon them. Okay, now when A has a clothing shop, so just like any other garment shop, he displays a various type of clothes with different color combinations, specifications with MRP tags upon them. This is what A is doing. A is basically doing is inviting people, inviting people that you come check out the collection and make an offer. You come check out the collection and make an offer. Then if A accepts your offer, then only he will sell you something. Otherwise, he is not bound to sell you something simply. Okay, now his objective is to send out the invitation that he is willing to deal with any person who, on basis of such invitation, is ready to enter into contract with him, subject to final terms and conditions. Okay, now what he is doing is A has just displayed the clothes. He is not making a general offer that anyone who comes and is willing to make a payment is entitled to enter into contract and buy the products from me. No, he can refuse you as well. Despite you are willing to pay the MRP of a shirt, suppose shirt, he may say no, I do not wish to sell it to you. Okay, he has a power to refuse you just like any other contract. You are making an offer. Now you are making an offer. When I go to the store, I pick a product and then I go to the cash counter. I am making the offer to cash counter that I want to buy this. Will you sell this to me? Then the ball is with cashier's court. Now the cashier will decide whether he is willing to accept my offer. If he accepts my offer, sale is conducted. If it does not accept my offer, sale will not be conducted. Okay. An advertisement for sale of goods by auction is an invitation to offer. Sometimes there are auctions of properties and goods and articles by government or non-government agencies, like auction of art products. We see a lot of time auction of antiques. There is a lot of times there is auction of antiques, vintages and art products. Okay, these auctions are an invitation to offer. Invitation to offer means we are inviting you to make an offer. You come, appear, take part and make an offer. Okay, you will, the one who is inviting, who is not making an offer, the one who is invited, who comes on the invitation, he is the one who will make an offer. Okay, it merely invites offers, bids made at the auction. Similarly, red herring prospectus. Red herring prospectus are when a company IPO in the public. IPO is when a company makes initial public offerings. Okay, then they issue a red herring prospectus. Okay, it is only an invitation to the public to make an offer to subscribe to the securities of company. The company is only making an invitation that you subscribe, you make an offer. You wish to subscribe to our IPO, our securities, you make an offer. If we are willing to accept your offer, we will allot you those securities. That is also a reason when people apply for IPO, so many of them do not succeed. So many of them do not even succeed in getting shares, though they have applied for the IPO. Why? Because the company has the final option of accepting or not accepting a contract. or an offer, sorry. A statement of intention and announcement. Offer must be distinguished from an answer to a question. Okay, offer must be distinguished from an answer to a question. Let us now understand it with the case law. In this case, Privy Council is the highest court, or used to be. Okay, it used to be the highest court of, sorry, not London, I should say Britain. Highest court of Britain, India, and South Africa, and all other countries who were the colonies of Britain in the previous era when we were slaves, when we were ruled by the Britishers. Okay, similarly, South Africa was also ruled by Britishers, and so many other countries. So, the highest court of appeal for all these countries used to be Privy Council, and this court used to sit in London. So, in this case, what happened in the case law is Harvey versus Facey. Okay, it is a case of 1893. In Harvey versus Facey, the Privy Council succinctly explained the distinction between an offer and an invitation to offer. Okay, they explain the difference between offer and an invitation to offer. In the given case, the plaintiffs, through a telegram, asked the defendants two questions. Okay, the plaintiff sent a telegram because there was no telephone in that time. So he sent a telegram and asked two questions. Will you sell bumper hall pen? Okay, this is the first question. Will you sell us bumper hall pen? The second question is telegraph the lowest cash price. It's 2 o'clock. The defendants replied through telegram that the lowest price for bumper hall pen is 900. Okay, so he made a query. They replied to the query. The lowest price for bumper hall pen is $900, 900 pound. The plaintiff sent another telegram stating, "We agree to buy bumper hall pen at 9,900 pound." However, the defendants refused to sell the property at the price. Okay, now the defendants refused to sell it. Now the man is Harvey. He took the case to Privy Council. Okay. Now what happened in the Privy Council? See, the plaintiff sued the defendants, contending that they had made an offer. The plaintiff contended that I made an offer, okay, to sell the property at 900, and therefore they are bound to that they made an offer to sell the property at 900, and I accepted their offer, therefore they are bound by the offer. However, the Privy Council did not agree with the plaintiffs on the ground that while plaintiffs had asked two questions, plaintiff had asked only two questions: Will you sell us bumper hall pen, and telegraph us the lowest price? Okay. The defendant replied only to the second question by quoting the lowest price. The defendant replied only second question. The lowest price for bumper hall pen is 900 pound. Okay. Defendant asked two questions. The second question by quoting the price, but did not answer the first question, but reserved their answer with regard to their willingness to sell. They had not replied to the first question because it is the lowest price. Definitely, they would try to sell it at a higher price. Lowest price is the bottom price. Okay, thus they made no offer at all. Their lordships held that the mere statement of the lowest price at which the vendor would sell contained no implied contract to sell to the person who had inquired about such price. So merely making inquiries about the price will not entitle you to enter into a contract because you have not made any offer. It is the seller who is going who is inviting you, and you must make an offer. It is only a question which he has replied, nothing else. The above decision was followed in Macpherson versus Apanna. Okay, this is an Indian case, ASC 18-4, where the owner of the property had said that he would not accept less than £6,000 for it. Okay, Macpherson, the owner of the property, Apanna asked Macpherson, "How much will you charge for the property?" The owner replied, I will not accept anything less than £6,000 for it. This statement did not indicate any offer but indicated only an invitation to offer. Okay, this is a statement, it is not an offer. This only indicates an offer that now you make an offer. I am willing to buy your property at £6,000. Are you willing to sell? Now, Aparna would make an offer. Okay, not Macpherson. Macpherson is only telling the price. Aparna should have made the offer. Okay, this statement did not indicate any offer but indicated only an invitation to offer. Similarly, when goods are sold through auction, when there is an auction of the goods, okay, like we discussed, art galleries are there. The auctioneer does not contract with anyone who attends the sale. Okay, the auctioneer has no contact with anyone who is attending the sale. The auction is only an advertisement to sell, but the items are not put for sale through persons who have come to the auction. Okay, may have intention to purchase. Similarly, decision was given in the case of Harris versus Nicholson. Okay, what happened in this case is, in this case, Harris versus Nicholson. Okay, what happened here? Harris wanted to buy an article through an auction which was happening some 500 kilometers away. He traveled 500 kilometer to take part in the auction. He was also the highest bidder. Okay, he was the highest bidder as well. But somehow the seller refused to conduct the auction at the last time. Seller says, "No, I have changed my mind. Now I do not wish to conduct the auction." Now Harris went to the court, and Harris contended that the sale of the property was conducted or the article was completed when I became the highest bidder. I have traveled 400 kilometers to take part in the auction and I have become the highest bidder. Now they cannot refuse to sell me the property. Okay, he sued the party for sale of the article as well as the travel cost which he had to incur. Okay, and then he had to again go back 400 kilometers, 800-kilometer journey for nothing. The court again in this case held that auction is only an invitation to make an offer. And when you reach an auction and you make an offer, that is up to the auctioneer now. That is with the auctioneer. Option is with the auctioneer whether he accepts your offer or not. Okay, if the offer is not accepted, then in that case there is no contract at all. The offer may be express or implied. An offer may be made either by the words or by conduct. Okay, an offer can be made either by conduct or by words, like we have discussed about the implied contract. Example is, a boy starts cleaning the car as it stops on the traffic signal without being asked to do so. In such circumstances, any reasonable man could guess that he expects to be paid for this. Here, boy makes an implied offer. The boy is making an implied offer. So now you allow the boy to clean the car. Okay, then you have to pay. Then you must pay. So people do not pay usually in these cases. In the typical case I'm talking about, because people consider it as an act of begging, but they should ideally stop this boy from cleaning the car. They should say, "Don't do it. I want to pay you. I will not pay you." And if he still keeps on cleaning, that is a different issue. But he is cleaning and you are sitting silently. That means he has made an implied offer and you have made an implied acceptance. Then you are bound to pay. A statement of price is not an offer. Okay, a statement of price is also not an offer. An offer should be distinguished from an invitation to offer. An offer is, see, we are discussing this particular issue again and again in detail. Why? Because this is a very crucial part of the contract formation, and a lot of questions are asked from this part only, that whether in this case it is an offer or an invitation to offer. So you must have a deep understanding of this particular topic. An offer should be distinguished from an invitation to offer. An offer is definite and capable of converting an intention into a contract. An offer, what is an offer? Offer is a definite offer and it is capable of converting an intention into a contract. Whereas an invitation to an offer is only a circulation of an offer. Okay, an invitation to offer is only a circulation to make offer. I am only inviting people to come and make an offer. It is an attempt to induce offerers and precedes a definite offer and precedes a definite offer. It is only an intention to attempt to induce offerers that you come and make an offer and precedes a definite offer. It invites people. Now these people will come and then what will happen? They will make an offer. An invitation to offer is an act precedent to making an offer. It is an act which is precedent to making an offer. Precedent means an act which comes before something. An act which happens before the final act. So the final act is making of an offer by the person who is so invited or the targeted person. Acceptance of an invitation to an offer does not result in the contract, and only an offer emerges in the process of negotiation. Okay. When a person advertises that he has stock of books to sell or houses to let means let on rent. There is no offer to be bound by any contract. Okay, he has made no offer. You cannot say that he has made a general offer. Or when we see the advertisement of Lux or Pepsodent or Colgate, that is not, they are not making an offer. Okay, that tomorrow if we wish to purchase, they have to purchase us. They have to sell to us in any case. No, they are not bound. Okay, such advertisements are offers to negotiate, offers to receive offers. They are only an offers to negotiate, that you come and enter into negotiations with us, or they are offers to receive offers. We are making an offer that you come and make an offer. We are willing to receive offers from you. In order to ascertain whether a particular statement amounts to an offer or an invitation to offer. Now, how do you identify whether a statement is an offer or an invitation to make an offer? The test would be the intention with which such statement is made. We'll have to understand the intention, we'll have to read the words of the offer very carefully in order to understand whether it is an offer or whether it's an invitation to offer. Okay. Does the person who made the statement intended to be bound by it as soon as it is accepted by the other? Okay. Or he intends to do some further act. If his intention is such that he intends to be bound by it, okay, then in this case it is an offer, it's a valid offer. But if he intends to do some further act before he becomes bound by it, then it is only an invitation to offer or invitation to treat also it is called. In former case, it amounts to an offer, and in the latter case, it is an invitation to offer. The list of goods does not constitute an offer for sale of certain goods on the listed price. Okay, they are saying the price list of goods does not constitute an offer for sale of certain goods on listed price. It is an invitation to offer. It's only a mere invitation to offer, that you come, you check out our goods, and then you make an offer, and then we'll decide whether we have to accept your offer or not. Difference between offer and invitation to make an offer. In terms of Section 2A of the Act, an offer is the final expression of willingness by the offerer to be bound by the offer should the other party choose to accept it. This is the definition given by section 2a, that what an offer is. An offer is the final expression of willingness by the offerer. It is a final expression, okay, not an initial expression, final expression. What is invitation to make an offer? It is an initial expression. It's a final expression of willingness by the offerer. The offerer is one who is making an offer to be bound by the offer should the other party choose to accept it. If the other party accepts it, then offer is complete. On the other hand, offers made with the intention to negotiate or offers to receive offers are known as invitation to offer. Sorry, there was something wrong with the process of the computer. It had hanged down, it had hanged. So, and coming back, thus, where a party, without expressing his final willingness, proposes certain terms on which he is willing to negotiate, he does not make an offer, okay, but only invites the other party to make an offer on those terms. Hence, the only thing that is required is the willingness of the offeree to abide by the terms of offer. Okay, this is a kind of a final offer on which nothing else is required but only the willingness of the offeree. Offeree means to one who's to whom the offer is made or addressed. Okay, that is called offer. In order to ascertain whether a particular statement amounts to an offer or an invitation to offer, the test would be intention with which such statement is made. The mere statement of the lowest price which the vendor would sell contains no implied contract to sell at that price to the person making the inquiry. If a person who makes the statement has the intention to be bound by it as soon as the other accepts, he is making an offer. Thus, the intention to be bound is an important factor to be considered in deciding whether a statement is an offer or invitation to offer. Following are the instances of invitation to offer, to buy or sell. An invitation by a company to the public to subscribe for its shares, that is called IPO. Display of goods for sale in the shop windows. Advertising auction sales and quotation of prices sent in reply to a query regarding price. These are instances of invitation to offer but not offer. Okay. Now, how to make an offer? How an offer is made? Offer can be made by either your act, either by doing some act, okay, or by not doing any act, either by doing some act or not doing any act, either by words or by conduct. Either it can be written or it can also be oral. These are the ways in which offer can be made. Definition of acceptance. Now, what is acceptance? We have understood what is offer. Now, what is acceptance? In terms of section 2b of the Act, the term acceptance is defined as follows: when the person to whom the proposal is made signifies his assent thereto. Okay, when the person to whom the proposal is made, he signifies his assent thereto. That yes, I agree. Proposal is said to be accepted. The proposal, when accepted, becomes a promise. Okay, the proposal, when it is accepted, it becomes a promise. When a person to whom proposal is made, for example, if A offers to sell his car to B for 2 lakh rupees, here proposal is made to B. A is making a proposal to B. A is making an offer to B. The person to whom proposal is made, i.e. B, in the above example, and if B signifies his assent. If B says, okay, I will buy. In other words, if B grants his consent on A's proposal, then we can say that B has signed, signified his consent on the proposal made by A. And when B has signified his consent on that proposal, we can say that the proposal has been accepted. Okay, accepted proposal becomes a promise, and then a contract is final. Now, relationship between offer and acceptance. According to Sir William Anson, acceptance is to offer what a lighted matchstick is to a train of gunpowder. Okay, acceptance is an offer. Acceptance is to offer what is the relation between acceptance and offer is acceptance has that relation with the offer which a lighted matchstick has a relation with the train of gunpowder. The effect of this observation is that what acceptance triggers cannot be recalled or undone. Okay, now there is a lighted matchstick which is put to a train of gunpowder. Then definitely what will happen? There will be great explosion or a fire, and this cannot be recalled or it cannot be undone. Okay, similar is the case between offer and acceptance. When an offer is made and the same has been accepted, then the offer cannot be undone or it cannot be recalled. Now the offerer is bound by his promise and the acceptor will secure the contract. But there is a choice to the person who had the train to remove it before the match is applied. Okay, but the person who has made the offer has a choice to withdraw or recall his offer before it is accepted. Okay, similar before the match is applied to the train. It in effect means that the offer can be withdrawn just before it is accepted. Acceptance converts the offer into a promise and then it is too late to revoke. This means as soon as the train of a gunpowder is lighted, it would explode. The train of gunpowder offer in itself is insert, but it is the lighted match, the acceptance, which causes the gunpowder to explode. The significance of this is an offer in itself cannot create any legal relationship, but it is the acceptance by the offeree which creates a legal relationship. Okay, it is the acceptance by the offeree which creates a legal relationship. Once that offer is accepted, then it becomes a final contract. An offer remains an offer so long as it is not accepted, but becomes a contract as soon as it is accepted. Legal rules regarding a valid acceptance. Acceptance can be given only by the person to whom the offer is made. Acceptance can be given by only the person to whom the offer is made. In case of specific offer, it can be accepted only by the person to whom it is made. Okay, now in this example, what happens? A makes an offer to B. B tells C that I accept A's offer. Now C tells it to A that B has accepted your offer. In this case, this is not a valid acceptance. Valid acceptance is when B himself conveys it to the A that I accept your offer. It should not come through the some third party. Okay, until and unless if this third party, if C is authorized, until and unless if C is authorized to act on behalf of B. Okay, if he is authorized to act on behalf of B or say A. If he is authorized to act on behalf of either of the people, then this acceptance will be a valid acceptance, otherwise it won't be a valid acceptance. The case law on this is case of Bolton versus Jones. It's 1857 case, even before the coming up of this contract act, because the contract act is 1872 but this case is 1857, just like we discussed. When there was no law, then people used to go to the court and court used to decide case on case by case basis as per their own wisdom. Bolton bought a business from Brocklehurst. Jones, who was Brocklehurst's creditor, placed an order with the Brocklehurst for the supply of certain goods. Okay, Bolton purchased the business from this Brockle. Okay, Jones, who was a Brocklehurst creditor. Okay, creditor means he had to take some money. He had to get some money from Brocklehurst. He placed an order with the Brocklehurst for the supply of certain goods. Bolton supplied the goods even though the order was not in his name. Bolton supplied the goods even though order was not in his name. Jones refused to pay Bolton for the goods because by entering into the contract with Brocklehurst, he intended to set off his debt against Brocklehurst. Okay, because what was the intention of Jones? Jones thought that Brocklehurst has to pay some money to me, but Brocklehurst will not pay the money to me. Okay, because Brocklehurst does not have money. So let us do one thing, put an order to the Brocklehurst and the Brocklehurst will provide me some articles and then I will not pay. I will say you set this payment against, set it off against the amount which is due towards you. Okay. So but meanwhile Bolton had come in and Bolton supplied it to the Jones. Jones refused to pay to the Bolton for the goods because by entering into the contract with Brocklehurst, he intended to set off his debt against Brocklehurst. Held as the offer was not made to Bolton, therefore there was no contract between Bolton and Jones. It was held because the offer was not made to Bolton. Offer was made to Brocklehurst, but still Bolton supplied the goods. So there was no contract between Bolton and Jones, and Bolton could not recover the money from the Jones. Okay. Why? Because Jones received the goods from the Brocklehurst, and Jones said, I set off my debt towards the Brocklehurst. Why Bolton supplied it to me? Bolton should not have supplied. That's it. And if Bolton supplied on the behalf of Brocklehurst, then Brocklehurst has due towards me, and then I refuse to pay because I set it off against my purchase. In case of general offer, it can be accepted by anyone who has the knowledge of the offer. Knowledge of the offer is the must, okay, like we discussed in the case of Gauridat versus Larman Shukla. So, in Carlyle versus Carbolic Smoke Ball Company case, we discussed in the previous slides, previous lectures. In this case, it was a general offer, and this Carlyle, she had the knowledge of this offer, public offer made by Carbolic Smoke Ball Company, and therefore she validly accepted that offer. Acceptance must be absolute and unqualified. It must be absolute and unqualified. Unqualified means having no further conditions attached to it. Okay, because if you are having some conditions attached, suppose if you have some conditions attached, we have discussed the situation, what will happen in that situation? It will cease to be an offer, it will cease to be an acceptance, it will become a okay, conditional or unqualified acceptance will automatically become a counter offer. So acceptance should be absolute and unqualified as per section 7 of the act. Acceptance is valid only when it is absolute and unqualified and is also expressed in some usual and reasonable manner unless the proposal prescribes the manner in which it must be accepted. If the proposal prescribes the manner in which it must be accepted, then it must be accepted accordingly. If the offer says that you have to accept the offer in such case, in this particular manner, then you must follow that manner. Otherwise, it won't be a valid offer. Suppose like we have government jobs, okay, government jobs, or we have to fill forms for IIT or JEE exams. Then in that case, IIT says form your admission forms or your examination forms should reach by post on this address. They should reach by post. This is the prescribed mode of accepting the offer by the IIT. If tomorrow somebody emails it, it will then in that case will not be a valid acceptance. If someone emails it won't be a valid acceptance. A inquires from B, will you purchase my car for 2 lakhs? If B replies, I shall purchase your car for 2 lakhs if you buy my motorcycle for 50,000. Here, B cannot be considered to have accepted the proposal. If on the other hand B agrees to purchase the car from A as per his proposal subject to the availability of valid registration certificate book for the car, then the acceptance is in place through the offer contained no mention of RC book. Okay. This is because expecting a valid title for the car is not a condition. Therefore, the acceptance in this case is unconditional. Okay, so you understand. In earlier case, he is saying you purchase my car, you purchase my bike, then only I'll purchase your car. This is a counter offer. Okay, this is a counter offer. But in this case, when he says I will buy, but if you have a valid RC of the car, so valid RC, expecting valid RC for the car along with a car is not a condition. It is expected that someone will provide it. So this is not a counter offer, it is acceptance. It's a valid acceptance. The acceptance must be communicated. The acceptance should also have to be communicated. You cannot just accept somebody's offer in your mind only, okay? You have to communicate it as well. To conclude a contract between the parties, the acceptance must be communicated in some perceptible form. Perceptible form means capable of understanding. Capable of being understood. Okay, any conditional acceptance or acceptance with varying or two defined conditions is no acceptance. Such conditional acceptance is a counter proposal and has to be accepted by the proposer. If the original proposal has to materialize into a contract, further, when a proposal is accepted, the offeree must have the knowledge of the offer made to him. Okay, if he does not have the knowledge, there can be no acceptance. The acceptance must relate specifically to the offer made, then only it can materialize into a contract. The above points will be clear. So that means offer first has to be communicated to the person, and when the offer has been communicated to the person, then only he can give a valid acceptance. Otherwise, he cannot give a valid acceptance, and when he gives a valid acceptance he will give the valid acceptance only in the prescribed form and must communicate that yes, I am willing to accept. Okay, this is Brojan versus Metropolitan Railway Company case. Let us see the case. B, a supplier sent a draft agreement relating to the supply of coal to the manager of railway company. Okay, Metropolitan Railway for his acceptance. B sent a draft agreement that I wish to enter into an agreement with this Metro Railways on these terms and conditions, and I'll supply coal. The manager wrote the word approved on same and put the draft agreement in the drawer of the table. Now what the manager did, manager wrote the word approved. Okay, he approved the agreement and put the draft agreement in the drawer of the table, intending to send it to the company's solicitors for a formal contract to be drawn up. Okay, he thought that I'll later on send it to the company's lawyers, they will draw a formal contract. By an oversight, the draft agreement remained in the drawer. Okay, but somehow he forgot to post it back to the supplier, that is B, and the approval letter stayed in the drawer only. Then what happened held that there was no contract as the manager had not communicated his acceptance to the supplier B. In this case, B later on came to know that this whole thing happened, so he filed a case against the Metropolitan Railway Company that when my contract was approved by the manager, and manager is the competent authority, when he had approved it, then my contract should be a valid contract and it should be enforced. Okay, but the company held but the court held that it was not a valid contract because the acceptance was not communicated. Merely accepting something and keeping that with me, so manager accepted it and kept it with his in his drawer only, so that means there is no valid contract at all because the acceptance was not communicated. M offered to sell his land to N for £280. N replied purporting to accept the offer but enclosed a cheque of £80 only. N replied that I am willing to buy but enclosed a cheque of £80 only. He promised to pay the balance 200 by monthly installments of £50 each. It was held that N could not enforce his acceptance because it was not an unqualified one. It should have been a it should have been an unqualified one. His payment was his mode of acceptance was a qualified acceptance that I will pay by the installments only. That is, now he is making a counter offer. It does not become an acceptance, it is a counter offer. If he wanted to make an acceptance, he should have readily sent £280. Okay, this is Neil versus Merit 1930. A offered to sell his house to B for 1 lakh rupees. Okay, A offers to sell his house to B for 1 lakh rupees. B replied that I can pay 80,000 for it. The offer of A is rejected by B. In this case, A's offer is I will sell the house for 1 lakh. B said I'll buy it only for 80,000. In this case, the earlier offer is nullified. It is rejected. Now this is the new offer, and in this case, B is the offerer and A is now offeree. Okay. B, however, changes his mind and is prepared to pay B, but later on changed his mind and said that I am willing to pay 1 lakh rupees as well. Now you sell the property to me. Okay, this is also treated as a counter offer and it is up to A whether to accept it or not. Now it is a counter offer and it is up to A whether he would accept it or not. In this case, A refused to accept it. So therefore, there was no sale conducted. Where an offer made by the intended offeree without the knowledge that an offer has been made to him cannot be deemed as an acceptance thereto. Okay, where an offer made by the intended offeree without the knowledge that an offer has been made to him cannot be deemed an acceptance. Bhagwan Das versus Girdhari Lal. A mere variation in the language, not involving any difference in substance, would not make the acceptance ineffective. Okay, mere variation in the language, like we just discussed the case of car, that I will purchase your car, but along with the RC certificate. That is a mere some difference in the substance. Okay, mere variation in the language will not make difference in the substance. What is the substance is that he is willing to accept the offer. In that case, offer or the acceptance shall be a valid acceptance. Okay. Acceptance must be in the prescribed mode. Acceptance should always come in the prescribed mode. Whether the mode of acceptance is prescribed in proposal, it must be accepted in the manner. But if the proposal does not insist on the proposal being accepted in the manner prescribed after it has been accepted, otherwise, not in the prescribed manner, the proposer is presumed to have consented to the acceptance. Okay. Now the IIT says you do one thing, you send me by post only, but I emailed it to the IIT. Then what IIT did, IIT emailed me back and said received, but IIT did not say that no, we do not accept it, you send it by the post, or they did not reply at all. Okay, they just say thank you. Then in this case, it is deemed that though my mode of acceptance was not the prescribed mode of acceptance, but still the act of IIT in saying thanks received was that they have accepted they have acknowledged my acceptance, and now the IIT is going to be bound. If the offerer prescribes acceptance through messenger and offeree sends acceptance by email, there is no acceptance of the offer. If the offerer informs the offeree that the acceptance is not according to the mode prescribed, okay, there is no acceptance if the offerer informs the offeree that acceptance is not according to the mode prescribed. But if offerer fails to do so, it will be presumed that he has accepted the acceptance and a valid contract will arise. Okay. Now Time. Acceptance must be given within the specified time limit. If no time is stipulated, acceptance must be given within the reasonable time and before the offer lapses. What is the reasonable time is nowhere defined in the law and thus would depend on the facts and circumstances of the each case. The substance is that if you want to accept an offer, you have to accept the offer within a reasonable time. So A makes an offer to B to purchase his onions. B replies after 7 months, and meanwhile, onions have been sold to somewhere else. Why? Because onion is a perishable commodity, and onion seller cannot wait for the reply till 7 months. Okay, so in that case, definitely acceptance is beyond reasonable time, so no contract at all. Okay, so what is the reasonable time will depend upon each case differently. Mere silence is not acceptance. Okay, the acceptance of an offer cannot be implied from the silence of the offeree or his failure to answer unless the offeree has in any previous conduct indicated that his silence is the evidence of acceptance. Mere silence will not be treated as an acceptance by the offeree unless he has previously engaged in a conduct in such conduct in which his his acceptance came only by the silence. Okay, if he has a behavior in which he accepts something by conveying his silence only, then only mere silence can be made an acceptance. Otherwise, acceptance has to be express. Okay, the case law is Feldhaus versus Bindley. F. Feldhaus is uncle of Bindley, offered to buy his nephew's horse for £30, saying, "If I hear no more about it, I shall consider the horse mine at pound 30." He says, "I want to buy your horse, but if I hear no more about it, if I do not hear anything about it from you, then I shall consider horse mine at £30." The nephew did not reply to F at all. He told auctioneer he told auctioneer B to keep the particular horse out of sale of his farm stock as he intended to reserve it for his uncle. By mistake, the auctioneer sold the horse. F sued for the conversion of the property. Held. F could not succeed as his nephew had not communicated the acceptance to him. Okay. Now what happened? He asked the auctioneer to keep this horse aside because I want to sell it to my uncle. But somehow auctioneer sold the horse. Now F sued the auctioneer that you have sold my property. F could not succeed as his nephew had not communicated the acceptance to him. Okay, mere silence is no acceptance unless this has been the prescribed mode. So, in this case, he could not show that this has been the prescribed mode of acceptance by Bindley. A subscribed for the weekly magazine for 1 year. Okay. Even after expiry of the subscription, the magazine company continued to send him magazine for 5 years, and also A continued to use the magazine but denied to pay the bills sent to him. A would be liable to pay as he continued use of the magazine was his acceptance of the offer. Now, in this case, it is not only the acceptance is not merely by silence, but he is using the goods. When he is using the goods, that means he has conveyed his acceptance by conduct. Acceptance by conduct, implied acceptance. Section 8 of the Act. This is the basically what example we discussed is acceptance by conduct. Section 8 of the Act lays down that the performance of the condition of proposal or the acceptance of any consideration for a reciprocal promise which may be offered with the proposal constitutes an acceptance of the proposal. This section provides the acceptance of proposal by conduct as against other modes of acceptance. Okay, so you can usually accept some offer either verbally or by a written communication, but also you can do it so by your conduct. How can you accept an offer by your conduct? It is very nicely explained in this example. Okay, some milkman drops milk outside my house. I consume it for a month. Every day he's been doing this, and after a month he sends me a bill. Then I say there is no contract between you and me. I never accepted your offer. Okay, willingly or in words or in written. So in that case, I will fail. Why? Because I have communicated my acceptance by my conduct. Therefore, when a person performs the act, okay, when a tradesman receives an order from a customer and executes the order by sending the books, the customer's orders for goods constitutes the offer, which has been accepted by the tradesman subsequently by sending the goods. It is a case of acceptance by conduct. It is a case of acceptance by conduct. So today we'll close this class here only.